So, hi everyone. Thank you again for coming on to learn about best legal practices in owning and operating rental property. Today we're going to talk about the new Bill 184, which I'm sure many of you heard a lot about. Some have not heard anything about. So I'm here to introduce the bill and provide clarity and answer questions. If we can reserve all questions to the very end, we can open the floor up for Q&A. So for those of you who don't know me, who don't know our company, head over to our social media pages, Facebook and Instagram, and follow us and like us. I always tend to put updates and videos pertaining to tenancy matters on our social media sites. If you ever have any questions regarding landlord and tenancy matters or prior to putting a lease together, please feel free to contact us. I am very responsive via email or via phone. So for those of you who don't know me, I will give you a brief introduction about myself. My path started in real estate in 2004, 2005, which led to acquiring landlord and investor clients who had purchased small to medium-sized apartment buildings and commercial plazas, but they were out of town and out of province, and they were not really involved into the day-to-day activities with running the rental business operation. So what happened was their tenants would contact me for everything. So everything being rental matters, maintenance issues, complaints, anything that involved with becoming a tenant and being a tenant. And what happened was, alongside my husband, we started a property management company to manage this portfolio. And then I would started going to the landlord and tenant board because of either non-payment of rent matters or illegal activities. And then 9 times out of 10, my matter would get dismissed because I was not a licensed paralegal or a lawyer. So I went back to school in order to obtain my paralegal license, and through that my business shifted, and now my legal firm is all that we do, and we always do is service realtors with their landlord and tenancy matters. So again, all my firm does is landlord and tenant matters and small claims court matters pertaining to real estate. So moving forward with this presentation, everything we discuss is for information only and not to be construed as legal advice. Again, if you have an issue or concern or question, feel free to contact me after this presentation. So let's talk about the landlord and tenant bill that has just passed. Effective July 21st, Bill 184 received royal assent. So what that means that it has now become law. Bill 184 is also referred to as Protecting Tenants and Strengthening Community Housing Act, or in short, Bill 184. This particular bill is viewed as a way to provide stability to Ontario's rental housing market by increasing fines for unlawful evictions or reinforcing the necessity for landlords to explore repayment agreements or repayment options before considering evictions. We're going to talk about that and what that means throughout the presentation as well. These changes would retroactively apply to going back March 17, when the province first declared a state of emergency over the COVID-19 pandemic. So during the period of March 17th to August 1st, where the board was closed, they were not holding in-person hearings pertaining to applications, more specifically landlord applications, which included an eviction as a result of non-payment of rent. So what the government and I guess the media was saying is that they wanted landlords and tenants to work together in order to come up with a repayment plan so that they can keep the tenants in their homes and that they can get the landlords paid. So I've reviewed this bill in its full entirety, and I've come up with 5 important points that realtors, more specifically realtors and investors and landlords, should know about this bill. And I've condensed it so that it's easy to understand for you guys. And also, at the end of this presentation, what I'm going to do is send a copy of all the slides to Tina and Aaron so that they can forward to you, just so that you can make reference to it and hang on to it. If you ever have any questions or if you're not clear about something, you can always refer back to the slides. So again, let's talk about what landlords and realtors need to know about Bill 184. So this is one out of the 5 things, top things that you should know. We're going to talk about compensation from former tenants, because pre-Bill 184, tenants must have been in possession of the rental unit in order for the landlord to go after them for, let's say, for example, rental arrears. Okay? Bill 184 allows the landlord to apply to the board, to the landlord and tenant board, after that tenant has moved out of the rental unit within 1 year from the date that that tenant moves out. This is great because now, if the tenant has moved out, now the landlord doesn't need to pursue legal action through the small claims court. They can pursue legal action through the landlord and tenant board. But the limitation period is up to 1 year from the date that that tenant moves out. So Bill 184 now also allows landlords to apply to the landlord and tenant board with respect to one tenant interfering with the reasonable enjoyment of another tenant. So what I mean is that the landlord no longer needs to play referee and interfere and go after that tenant who's causing trouble or causing interference with the reasonable enjoyment of other tenant, because now the tenant can use the landlord can use the tenants that are complaining on the application to strengthen the application to go after the tenant who is causing an interference. And by interference, I refer to making excessive noise or smoking in the common areas or even smoking in the unit, which either goes under the door and affects the common areas, or through the vents can affect other units, other joining units. Now let's talk about utilities, because our office often gets overwhelmed from phone calls from realtors with respect to unpaid utilities. And pre-COVID, the landlord would not be able to recover unpaid utilities through the landlord and tenant board. Well, now the Bill 184 allows landlords to recoup unpaid utilities from tenants within 1 year from the date that that tenant has moved out by bringing an application to the board. So this is great. This means that landlords will no longer be restricted from pursuing a former tenant from compensation after that tenant has moved out, which was the case prior to Bill 184. Because prior to Bill 184, if a tenant moves out, again, the landlord has to pursue a legal action through the small claims court. Again, this makes it easier for landlords to recover unpaid arrears and unpaid utilities through the landlord and tenant board. So number 2, illegal rent increases deemed not void. So Bill 184 would say that a tenant cannot seek reimbursement for an improper rent increase if the tenant has already paid the increase of rent for at least 12 consecutive months, provided that the tenant did not make an application to the landlord and tenant board challenging the validity of the increase within 1 year from the date that that increase was first charged. So what does this mean? What does point 2 mean? As I'm sure you all know, that a legal rent increase has its own criteria. So a legal rent increase has to be provided via notice in writing, giving the tenant 90 days written notice of that rent increase. More importantly, that rent increase has to be as per the rent increase guideline, which is set by the ministry. So for example, for 2020, the rent increase guideline is 2.2%. Now, some landlords who either they don't want to abide by the law or who genuinely don't know that a rent increase guideline exists would have served not not legal notice, but either an email or via verbal notice that, hey, I'm increasing the rent by $100, $200, $300. That tenant, pre-Bill 184, can bring an application against the landlord to seek a full refund of any illegal rent monies that they've given to the landlord. Well, Bill 184, in a sense, protects that landlord in the way that if that tenant has paid the rent increase or the legal rent increase for 12 consecutive months, that illegal rent increase will be deemed not void. So that tenant does not have the board's protection for a refund. So again, this could be good for the landlord, not so much for the tenant. Okay, so number 3, increased cost consequences of terminating tenancy and bad faith. Currently, on a tenant's bad faith application, which is an N12, more specifically pertaining to your business as a realtor, when you're selling a property that's tenanted, upon the acceptance of a firm agreement of purchase and sale, the landlord or the landlord's legal rep would serve a notice of N12 to terminate tenancy for the purchaser's own use, giving the tenant 60 days notice to vacate the property before the landlord can pursue legal action to evict them. Well, if this notice was deemed to be served on bad faith, the tenant can bring an application, a T5 application on bad faith against the landlord and ask the board to remedy them by awarding them out-of-pocket expenses, rent abatements, storage or moving costs, up to $35,000. Well, the tenant can also ask for the difference in rent of what the former rent was and what the new rent is times 12 months, so for up to 1 year. Bill 184 now allows the landlord and tenant board to award much higher costs to tenants of 12 months rent at a full monthly rate charged by the landlord to that tenant. So again, up to $35,000, tenants can claim against the landlord on any bad faith application. So landlords, beware. Please do not serve any notice on bad faith. So number 4, affidavits are now required in connection with applications to landlord and tenant board terminating a tenancy. So this is not new. This is not something new for me because I've always had affidavits signed in order to protect my landlords and my realtors when it comes to any legal application with respect to terminating tenancy because the new purchaser wants possession of the property. Well, Bill 184 now makes it law that landlords must include an affidavit setting out the particulars and reasons for termination. The landlords must also include in this affidavit whether or not they have, within 2 years of filing the present application, given any other notice of termination to that tenant. So now it has to be disclosed to the board if an additional N12 has ever been served to that tenant in the past by that landlord. So again, this will be considered if you're asking the board to terminate tenancy for the purchaser's possession. You must include if any bad faith notices have been served to the tenant prior to the new notice being served. All right, penalties. So number 5, penalties. Corporations, beware. This is really, really important because right now we are in the newborn stages of Bill 184. This means we're very early in the process. There's no case law. The board is looking to make an example out of anyone. So whether you are a small-time corporation, whether you're a mom and pop landlord, or whether you're a multi-million-dollar corporation, if corporations are convicted pre-COVID, pre-Bill 184, not COVID, they were liable to pay fines of up to $100,000. Bill 184 increases that maximum fine for corporations to $250,000. So corporations, beware. Again, do not serve any notice on bad faith because the board right now, they're looking to make an example out of you. So let's talk about fast-track evictions, because again, this is another concern that my office is being overwhelmed with calls about, is that the media has put it under the limelight that a landlord can now bypass going through the board and get a fast-track eviction if they came up with a repayment plan and the tenant has breached it. So again, because we're in the newborn stages of Bill 184, there still needs to be a hearing. So what does Bill 184, how does Bill 184 cover fast track evictions? Well, Bill 184 now says that a landlord can give a tenant without prior consent or without any consent, basically a take it or leave it repayment plan with terms that are unaffordable or unrealistic for that tenant, and they can include a clause that permits the landlord to seek an eviction, or more importantly, it's called an ex parte notice or notice without a hearing, if that tenant breaches the agreement. So if a tenant receives this particular eviction order, they had, prior to Bill 184, 11 days. Now they have 10 days to bring a motion to set aside or put a hold on that eviction order and request a hearing so that they can be heard to explain their circumstances. So, in other words, if a tenant does not sign a repayment plan, a hearing will be set anyways. There's no way to bypass your hearing at the board and get an order to evict. So a hearing will be set anyways, and that tenant will have to explain to the adjudicator or the board member why they did not agree to signing a repayment plan or any agreement to make those arrears payments. Okay, so we're coming to close to the end of this Zoominar. Again, I don't sell anything. All my information is free. All my Zoominars are free. I've put together this landlord mastery guide, and this is based on my own experience, both as a landlord, as a realtor, as a broker, as a property manager, and now as a legal representative. This is free to download. I'm going to send a copy of this presentation to Tina and Aaron. And this basically, you can use it for yourselves in your business, or you can forward it to your clients. This shows you how to qualify tenant prospects, what questions you can ask, what a landlord can legally request. It's filled with scripts and forms, other agreements such as parking agreements, air conditioning agreements. You have to just make a note here that whenever you're putting the Ontario Standard Lease together, even though you're including parking in the Ontario Standard Lease, agreements like parking and air conditioning should always be side agreements. So keep that in mind. This also has a legal notice of entry, which is blank. You can just download it, fill it out, and use it for your clients or yourselves. And how to prepare a property for lease. Keep in mind, anytime you or your clients own real estate, you own a business. You're in the business of landlording. And like any business, the landlord is the business owner and the tenant is the consumer. So like any business, if the tenant is not happy or if the consumer is not happy, the business owner or the landlord is not happy because they're not getting paid. So you have to advise your clients to change their mindset. You change your mindset. Those are gone where you purchase property and you sat back to collect the rent, and ever, landlords have to be active in their business of rental properties, because tenants have access and rights to the landlord and tenant board. And I'll tell you, the board will back them if they have any maintenance or repairs concerns, or if they have any tenants' rights concerns. The board will back them. So you have to have a very active landlord um, in order for your rental business to run smoothly. Again, I'll send a copy of this presentation to Tina and Aaron. And again, they can forward it to you guys to click to download a copy of this landlord mastery. So we're come to the end of the Zoominar. I would turn the floor over to Tina or Aaron, and we can open it up for questions. You can ask me questions regarding Bill 184 or any of your tenancy questions.
First question, we have a couple of people asking the meaning of bad faith.
Bad faith is when a notice is served that has that is not real and genuine on its face. Meaning, so for example, I get calls saying, Vida, can we terminate tenancy because I don't like this tenant, or my tenant is not returning my phone calls. I want to terminate tenancy. Can't I just say that I want the property for myself or my child? And then we serve the notice, or that landlord serves the notice, and then once the tenant vacates, 2 or 3 months down the line, they see an ad on Realtor.ca or on Kijiji that the unit is up for rent for $300 or $400 or $500 more. That tenant can bring a bad faith application because they relied on that notice in order to move. So there are 3 factors that the board will look at to determine if a notice is served on bad faith. So number 1, if that tenant relied on that notice to make a move. Number 2, if that unit was advertised, the unit or the rental property was advertised. Keep in mind that they can call up any realtor to pull up an MLS listing because, again, it's free information. Or they can go on Realtor.ca, or with apps like House Sigma, they can pull up the last sold or the last leased property, and they can use that as evidence. And number 3 is if the person that was supposed to move into the rental property did not move in. Any breach of the 3 that I've mentioned is deemed to be served on bad faith.
Do we need a separate agreement for air conditioning and parking?
Absolutely. I would recommend a separate air conditioning and parking agreement. Again, one parking agreement, one separate air conditioning agreement. Because what happens is usually if a parking is included in the rent, you cannot charge a parking fee. But if you wanted to charge a parking fee per vehicle, that parking agreement would allow you to do that. And that parking agreement would allow you to increase the fee for the parking spot, not per the board guideline.
My client's basement tenant hasn't paid for almost 8 months. LTB has not been available. What's their option now?
Well, I hope you have served them with a notice to terminate their tenancy for non-payment of rent. That's the first step. You don't need to issue 8 of them. You only need to issue 1, and it must be filed with the board. The reason why you want to file it with the board is that you want the board to hold a hearing in order for you to get an eviction if the tenant does not pay the arrears. The problem you're going to have if you haven't started the process is that right now the board is in receipt of 80,000 applications. Okay, 90% of those applications are landlord applications, meaning if you have not already started the process, your application is all the way at the end, which means that pre-COVID, what took 5 months of time to get a hearing date because of backlog and the board being understaffed is now going to take you double time, right? So now that you haven't been paid for 8 months, with you having to wait 7, 8, 9 months, it's going to be on top of the 8 months that you already have not been paid your rent.
Hi, I just had a question. If I have a property and I haven't increased the rent in something like 6 years, and I noticed the amounts of rents have been going up consistently. If I choose to raise the rent, can I raise it to what is being rented in the area, or am I limited to the 2% increase?
So you are limited to the rent increase guideline, which for 2020 is the 2.2%.
2.2%. Okay.
Which means, Paul, is that if you wanted to increase it for 2020, and that would take effect December 1st, you don't have much time to serve it by hand deliver it, because you don't have the time to mail it.
Right. I just wanted to find out if I'm limited to that 2%. Okay.
Yeah,
That's
you
all
are
it is.
limited to the 2.2%.
Yeah. Okay. Very good. Thank you.
Yeah, hi, thank you for presentation. I am in the process of buying investment property for a client, and actually we had a situation with one property. There is a tenant there for like 15 years, and the seller was emphasizing that like buy the property and assume the tenant, but we didn't want to, so we didn't offer the property. We didn't do any offer. My question is that we cannot really ask for a vacancy, right? Because the tenant is there, they cannot get her out, we cannot get her out either, right?
Well, what is it that your client wants to do with the property? That's a better question, because if your client wants to move in, then you can get her out, because a legal notice can be served and filed with the board for in order to evict the tenant doesn't move out. But if your client wants to purchase the property so that they can re-rent it at a higher amount, that notice will be served on bad faith, and therefore that tenant, the former tenant, can come after not only the former landlord, but the new landlord and the realtors and the brokerages. So you got to be really, really, really careful. First of all, as realtors, you're not allowed to issue any legal notice, not on behalf of your clients, because you will be held liable and your brokerage will be held liable. And more importantly, your insurance, your errors and omissions insurance, will not cover you. Okay, so again, it depends on what your clients want to use the property for. If they want to move into the property, definitely a legal notice can be served, because the new purchaser wants to use the property for their own purpose. But if they want the property in order to up the rent 500-600, whatever the case is, because the rent is below what it should be, then you cannot serve a legal notice. No.
But can we arrange a new agreement with the tenant?
Not with the same tenants. No.
Not with the same tenants.
No, so what a lot of realtors also ask me is, can they sign a new lease at a higher amount with the same tenants? And the answer to that is no. The board will not allow that.
And if we buy it, if he basically doesn't move in the next 2 months after closing, and whatever, the tenant who moved out can go and make a complaint that we bought it for my buyer own use, and they changed their mind, so they didn't move in. So that's going to be again bad faith, right?
Huge bad faith. Huge.
Okay.
I'll tell you why. Just because your client changed their mind is not an excuse.
It's not an excuse.
The law is not an excuse, and I'll tell you, that will not fly with the board.
No, I know that.
Not at all. So just make sure, if you're going to put an offer together for a property that is tenanted, call me first. I will send a Schedule A or Schedule B. You can add it to your offer, protecting not only the agent, but the brokerage and your client, and more specifically, outlining the steps required in regards to amending the closing date if the tenant does not leave. Because on the N12, it says on the second page, it says, if you don't agree with this notice, you don't have to move out. That it allows the tenant to do that, which means that the landlord must proceed with the board hearing. And at the board hearing, the tenant can say, well, I haven't been able to find a property, a rental property at the same amount of rent or less, and I need more time. This is just a delay tactic. So you want to make sure that if it goes that route, that the tenant does not move out, you have that flexibility to amend your closing date. You want to make sure, otherwise the buyer will back out.
So the question is, if you tell your tenant that a family member will come and live in the property, but you serve them N9, so there is no record, there is no evidence that it's just a verbal things. So what's happened?
So who is serving the N9?
The owner.
Okay, so the N9 is not the correct notice to serve. The N9 requires, that is a tenant's notice to terminate tenancy. There are 3 ways that a tenancy can be terminated. Number 1 is the N9, which is the tenant giving notice to the landlord, and that notice has to be 60 days. Number 2 is the N11, which in your case would be the correct notice to serve. And the N11 is a mutual agreement to terminate tenancy. It's like the mutual release, right? All parties agree to terminate tenancy on such and such a date. And number 3, by way of board or court order. So the correct notice is the N11 that your clients should have served. But if it's the N9 that is signed with the 60 days, if all the elements are there and the landlord puts it up for rent, provided that there's nothing in writing that exists saying that the landlord wants the property for their son, or nothing is implied on bad faith, then the landlord will not be held liable. because it's not the right legal notice.
Peter, in terms of the N12, when a buyer is going to occupy the property, I believe you said that the buyer also has to file an affidavit. Is that correct?
The buyer, I would recommend to sign an affidavit. The landlord or the seller for sure would have to sign an affidavit.
Right, and so when N12 is completed, like in our situation here, a vacant possession notice is given for the seller to give the proper notice, the N12, to the tenant that the buyer is going to occupy the property. Does that N12 have to have an affidavit at that time accompanying, like does that have to be stapled to the N12, or like when is the affidavit required?
So the N12 can be served to the tenant. It is not a requirement to serve an affidavit to the tenant. The only requirement that the board has is to serve the N12 and to pay compensation before termination, before the termination date set out in the N12. So there's no termination of tenancy, or the board will not terminate tenancy and issue an order if compensation was not paid before the termination date. That affidavit is a requirement to satisfy the board's condition. So to answer your question, that affidavit is to be sent to the board along with a copy of the agreement of purchase and sale showing that the property has sold firm, including all waivers and amendments.
And so that has to be done every time a sale happens in this scenario?
I highly, highly recommend it, yes.
Wow.
If the tenant does not leave, you're going to have a problem.
Right.
That means the buyers have already given notice from where they are. That means that the sellers cannot move in order to transfer funds to what they want to do, and the tenant is holding the property hostage. The board is the only institution that has the power to terminate tenancy and issue an order to evict.
But the problem there that I see, if you don't mind taking just an extra moment, the problem I see there is all of a sudden the tenant doesn't move out. There's an order to evict. The tenant plays the game, and 10 months later, the house still hasn't closed. The tenant still lives there, and the buyer and the seller are beat. Is that what you're basically saying?
I hope it doesn't take that long, but it could. That's why the schedule that I'm going to send you guys will protect you, and everybody will agree to amend the closing date and an additional 4 months because of all the backlog, right? So it's 60 days for the closing plus another additional 120 days. Keep in mind, as an agent, I know how hard you guys work in order to put an offer together. So the last thing you want is to have the deal fall apart because a tenant doesn't want to leave. That's why those clauses in the schedule are there to protect the sale.
Okay, thank you very much, Peter. Much appreciated. Thank you.
Anytime. And at any time, if you guys have any questions or if you forget what I've mentioned here, please do give me a call or send me an email. I'm a lot quicker on email to respond.
Yeah, so when buying a tenanted property for personal use, how long do the new owners have to live in that property until it can be leased out again? So as bad faith is not in place.
At least 1 year.
Okay, good.
And it has to be for residential use. It cannot be that you're going to be selling your products or operating a hairdressing salon or any business operation. It has to be for residential use.
Yeah, a quick question about the standard lease agreement. So basically, I want to know which one comes before, because sometimes in Form 100 and the Form 100, you mentioned about the repairs or some other items when you will put an offer. So everything is signed, and within 21 days, that standard lease has to be signed. But sometimes all the items are not covered on both. So I was wondering what happens in case something rises up between tenant and landlord in these cases.
Okay, so let me just briefly go over the difference between Form 400 and the Ontario Standard Lease. Form 400 is an agreement to lease. It's an offer to lease, just like the agreement of purchase sale. And it's more to satisfy the brokerage's conditions, so that when they get audited, or if they get audited, they have the correct paperwork. Upon the acceptance of Form 400, which is, a smaller agreement, it doesn't have all the terms and conditions as required under the law, which is the Residential Tenancies Act. That is why the Ontario Standard Lease is required to be signed. Once the Ontario Standard Lease Agreement is signed, this is the lease in its full entirety. This has all the clauses pertaining to what the law will and will not allow. Now, you can, instead of attaching schedules to Form 400, I would recommend to attach your schedules to the Ontario Standard Lease. However, now keep in mind, a landlord and tenant can agree on whatever terms and conditions they want in Form 400 and in the Ontario Standard Lease. However, what the law says overrides your lease. Your lease is basically an understanding between the landlord and tenant. Okay, so what I mean is that if there are any inconsistent terms in your lease that are inconsistent with the act would override your lease.
Before the next question, I just want to ask a question that related to the previous question. How many showings is too many showings for a 24-hour notice to the tenant? When does it become, I guess, disturbing the tenant? How do you deal with that?
So when the tenant says that it's getting out of line, it's getting out of hand.
Okay.
Right? So 1 or 2 showings, 3 showings, 4 showings. To me, what's excessive to me may not be excessive to you, right? So to me, every hour that an appointment is booked should be allowed. But again, I'm not the person living there. I'm not the tenant living there and controlling the property. And that's what you have to keep in mind. Anytime a property is tenanted, that tenant controls the property.
The standard form lease or the Ontario lease in place, if it's not in place, if they didn't sign one, what will happen?
So whether or not the Ontario Standard Lease Agreement or any lease agreement exists, the law governing landlord and tenancy matters takes effect. So it doesn't really matter if you have a lease or not. The law says what the law says.
And does the law not say that an Ontario lease must be signed?
The law says it must be signed, but sometimes, especially if you have the old school landlords who don't get a lease signed, who go based on a handshake.
Yeah, the law is still there, but there's no penalties to that landlord should they complain. Julie is asking, I'm having a mess with my tenants and serve them in the N5 and was wondering if it's okay to serve by email or I have to send by mail or courier.
Okay, so the landlord and tenant board has their own methods of acceptable, what's acceptable as service. Email is not an acceptable method of service. I have to tell you, the real estate industry has really evolved with technology, which is fantastic. The world of law, not so much. We're still using fax machines, right? We can't use PDF. We can't send anything via PDF or emails because we're not there yet. So if you're serving a notice via email and it goes to the board, because you have to provide to the board a certificate of service, which is like an affidavit of service, showing the board how you serve this notice. And if they do see via email, well, it's not an acceptable method of service, it will get dismissed. Mail or courier is an acceptable method of service. However, if you do choose to serve via mail or courier, you have to add 5 days to the termination date in your notice.
Just to verify, is the seller that should give this tenant an N12 for a sold property, or is this the buyer's responsibility?
So the new purchaser, which the new buyers would request vacant possession either in Schedule A, or if they don't request vacant possession, it's already built in next to the completion date clause that the seller will provide vacant possession. So it's the seller who is the landlord who provides the notice, the N12 for the sold property to the tenant. If it is served by the new purchaser and the tenant doesn't leave and it goes to the board, well, the new purchaser is not the landlord. That would deem your notice defective and your notice would get dismissed at the board.
Again, to clarify this, Beta, because it's kind of confusing, I guess. And to Jeff's point, earlier you stated the tenant cannot refuse showings. I mean, you give 24-hour notice for showings, but then you're saying that they can also say, no, I can only do it Tuesdays 4 to 6. So which one's right and which one's, how do you do that?
So they cannot refuse showings. Okay, they cannot refuse it. By restricting the showings, they haven't refused it. I don't know the reason why they're restricting it. My whole blurb around that is you should accommodate the tenant. Because if you say to the tenant, well, no, we're not going to accommodate you Tuesdays between 4 and 6, we're going to come Monday to Friday 9 to 9 or 8 to 8, or whatever the case is, the last thing you want is a tenant who says, hold on, no, you're not. I'm going to refuse your showings. Right? So even though the law doesn't allow the tenant to interfere, at the end of the day, we're all people. We have a mutual goal, or you have a mutual goal, and your goal is to list the property, and your seller's goal is to sell the property. And if you don't accommodate that tenant, you're not going to reach your goal.
Yeah. I've been to the landlord tenant board once, and I just found that whole process to be a lot of common sense stuff too. It's, as much as there's rules and regulations, it usually is the person that's not being reasonable that suffers the stiff hand of the board, So is essentially what you're saying, right? I mean, just try and be human beings and everything will work out.
That's right. Unless they're not paying rent, then you have to proceed it.
Exactly.
Yeah.
Last question, just to finish everything off. When do you expect the landlord and tenant boards will be back open in York region?
This is the golden question, right? Thank you, Farshid, for asking that. This is the golden question. I get asked this question at least 10 times a day. So the board has resumed operation as of August 1st. They're not open, which means that they're not holding in-person hearings, and you cannot file your documents in person. You can do them online via fax or at Service Ontario. However, they are holding video hearings, and they are holding telephone hearings now for landlord applications.
I'm sure we could actually keep going on, but we're after 2, so I didn't want to take too much more of your time. If anybody has any other questions and you want to either email Beta or give her a call, she has given that option up to everyone, so that's amazing. And what a great resource. I really appreciate Beta coming in because you do a great job, Beta, really, and it's very useful. So we're going to continue, hopefully, if you'll come back to continue to, have you come in and talk to us about landlord tenant stuff. That'd be great.
Excellent. You know what, Aaron, because I'm getting the feel that there's a lot of questions surrounding the N12 and leases, I'd be more than happy to work on a presentation just surrounding those two, that notice and the lease, so that it's more informative and I provide more clarity for you guys. So I'll definitely set that up with Aaron and Tina for you guys.
Okay.
And again, I'll send over the schedules and
Yes.
this presentation, the slides.
That'd be great. If you do that, what we'll do is we'll send out an email to everybody in the company with regards to that schedule, as well as your information for everyone.
Excellent. I appreciate that.
Thanks, Ida.
Thanks, guys.
Take care.
Bye for now.